Hi there, Mark Kelly here from Canuka. I had been doing some presentations in the past for both lawyers and some realtors about the prohibition on the purchase of residential properties by non-Canadian here in Canada, and there had been recently some amendments to the regulations that were involved in those pieces of the legislation. So I thought I'd just pop on and talk a little bit about what those changes were and how they may impact you or some future clients in terms of how some transactions that were previously not allowed would now be allowed. So um, there are kind of three most significant changes that had been made to it. The first significant change is just around those who are under a working permit under the immigration regulations. The previous section under the Act had indicated that if you were someone who held a work permit, as indicated by the Immigration and Refugee Protection Regulations, or were authorized to work in Canada under a relevant section of those regulations, you had to have worked full-time for 3 of the previous 4 years. You had to file income tax, and you could not have owned more than one residential property. They've changed that now. They've simplified it quite a bit, and all that they require now is that as of the date of purchase, that the non-Canadian would have required to have 183 days more validity remaining on their work permit. And as long as that's the case, and they haven't purchased more than one residential property, then they can make the purchase that they wouldn't have been allowed to under the previous regulations. So there's no need to kind of evaluate if they've working full time or if they've got to filed income tax returns. That may come up as part of some lending criteria or something of that fact. It's really just how much time they have left on their work permit. The second issue that came up was, and it's kind of related, I guess, to the third, is vacant land. So there was a section in the regulations before, and the section had indicated that for the purposes of kind of what was defined as residential property, that land that did not contain any habitable dwelling that is zoned for residential or mixed use and that is located kind of in the area that's noted under the legislation would be a prescribed piece of real property, which would mean that it would fall under the confines of the Act. So, if you have if you had a vacant lot, you couldn't purchase it as a non-Canadian as defined by that legislation. They have since just completely deleted that section. And then they ended up changing or adding an exception. So previously the exceptions were things like if you got it as a gift, or if it was a rental or those sorts of things. The new amendment indicates that you can acquire by the acquisition of by a non-Canadian of residential property for the purposes of development is considered to be an exemption to the legislation. So the problem being is that development is not otherwise defined by the legislation at all. So they have produced kind of an interpretive guideline through CMHC, which describes what is considered a development. And I'll put that link at the bottom of the video. Again, they note specifically on this link that it's for general guidance and not to be construed as legal or professional advice. And it's not technically binding, but I guess it would be instructive as to when they would consider the enforcement of the legislation. With it, they have indicated a couple of key kind of concept as to when it would be considered development and when it would not be development. I'm just going to pull that up here for 2 seconds. So with it, so they mentioned that some non-exhaustive factors that may indicate that an alteration or improvement constitutes in development would include things like you have to engage the applicable review and approval processes of the relevant municipality or other land use planning regulator. You may have like an alteration or improvement that's accompanied by a change in use that would also be considered, a commercial or industrial, residential, retail, office, agricultural, resources extraction, or other recognized or permitted land uses, which could just describe it as a development. They then go on to say things that would not be considered a development. So, for example, you can't purchase it for the sole purpose of just leasing or renting the property from it being otherwise considered just a owner occupied property. That's not a development. Or similarly, if you do what are kind of, I think they're describing as more surface renovations to the property. So a non-exhaustive list of some alterations which do not consider development include expanding existing dwelling unit, remodeling existing dwelling unit, redesigning interior space, adding a porch, deck, or patio, or finishing an unfinished basement. They note, though, however, when expansion or remodel is so extensive that it is tantamount to the construction of a new building or a change of use, for example, because it creates a new residential property, other types of new independent usable premises, this would be considered development. So it's kind of a, are you putting some paint up and changing some flooring, or are you doing a major overhaul to the point that it is considered essentially a brand new building? Combined with that section about bare land, they do note that they ask it as a separate question whether or not the construction of new property on land would constitute a development for the purposes of that exception. They say yes, the construction of a new building or the undertaking or other forms of other forms of development could be considered development for purposes of this exception, even without any alteration or of existing structures on the purchased property. So that is kind of contemplated in this new these new amendments. Last piece, they talk about whether or not you try to go ahead with a development and then it fails or you offside the act. And they say no, but you have to be able to demonstrate kind of a good faith intention at the time that you purchased it to undertake the development that was contemplated. So you can't just buy a property as a non-Canadian and say, oh, I've got big plans to do this, and then never follow through with any of them and say, well, this should be exempt because I thought I might develop it. They want to see a kind of information from lawyers, architects, real estate agents, etc., that would say that you had plans to do X, Y, and Z, and it wasn't able to happen because of some additional information that you got at some point in time. The only other changes to note from the amendments to the regulations were around some of the corporate aspects of what's considered non-Canadian. So if before, if you had a corporation that was held by more than 3% of non-Canadians, or if either by value or by share or control, then that would be considered a non-Canadian for the purpose of the legislation. They have changed that now up to 10%. There's also an amendment in the regulations that I think is just basically a cleanup of some of the drafting. There was an interpretive issue around whether kind of the entities, non-corporate entities, would be captured by this in a way that wasn't kind of, I think, contemplated or expected by the act. And so they cleared up some of the language just to sort that out. So if you are dealing with non-Canadian entities or corporations, it's probably just a good idea to look at the regulations and just understand what's going on there. That's it for me, but if you've got any questions, feel free to reach out, mkelly@kanuka, kanuka.ca, and I'd be happy to share what I know. Thanks so much.